Over the years, I've gotten a lot of phone calls from victims or alleged victims in domestic violence related cases who are looking to have a no contact order lifted. And it's reached a point where I think it's worth talking about so that people have some basic ideas of what they're asking a lawyer to do in these kinds of cases and what their expectations should be. And in order to even open that can of worms, you have to first realize that anytime that you're talking about a domestic violence case, you always have to realize that there is an issue at play, that even if it's not spoken, it's at play. And that is whether or not the person who's asking to have a no contact order lifted, an alleged victim or victim, whether they're doing so on their own volition or not, whether they're doing so and are capable of protecting their own interests, whether they're doing so with the ability to call the police if they were assaulted again, whether they, or if they're doing so, do they have a plan if things go wrong? Because part of that unspoken issue is got to explore whether it requires people to recognize that domestic violence cases, especially when it involves a man and a woman and involves a man hitting a woman, opens up the possibility that the man who has hit the woman has not just hit the woman once, but has engaged in a pattern and course of abuse, physical, emotional, mental, such that they have convinced their partner, generally the female, to act in a way that isn't in their own best interest if they were clear-headed, but to engage in a relationship which is unhealthy and which is destructive, and is sufficiently destructive and unhealthy that it would allow somebody who has had their arm broken or had them been punched to go ahead and ask a court to lift an order so that that person who punched them or broke their arm or whatever the story is can come back in their life again and do it more. Because part of what a cycle of violence is the very nature of it requires a sort of cyclical pattern. And it may not be every month, it may not be every 2 months, it may not be every week, it can be on a yearly basis, it can be a lot of things, but there is a cyclical pattern where physical abuse always is going to continue to manifest itself in those kinds of relationships. And so courts that are looking at no contact orders and looking at victims that are asking, or alleged victims that are asking to have a no contact order, have an acute eye and an acute awareness that they are concerned that that victim who is asking, or alleged victim who's asking to have that no contact order, is somebody who is subject to the control of the perpetrator, of the person who's charged, such that they're going to ask to lift a no contact order so they can get beaten up again inevitably, and involve the court system again inevitably, and the police system again inevitably, and they don't want to open that door. And so what you'll have in some cases is a court saying, hey, we're going to enter a no contact order, and I don't care what the victim has to say on this. This is a pattern of domestic violence, and I don't want these two people interacting together for societal reasons and for the cost it is on the court system and the cost it is on the police system, and it's unhealthy. It's not good. You know, getting beaten up on a cyclical basis is not a good, generally is not a good way to live your life. So when you walk into these kinds of cases, you have to realize that you either can't fit that profile or you can't be that profile if you're going to ask to have a no contact order lifted. And what courts really want to hear is that the victim who is asking to have a no contact order lifted is capable of independent thinking and acting in their own best interest. And so what they want to hear is things like that the person who's asking to have the no contact order lifted has a safety plan if things go wrong. They want to know that they're independent and they can act in their own interest. They want to know the facts that would lead somebody to believe that they could be independent and act in their own interests. They want to know that they'll call the police if abuse or threats of abuse or dangerous behavior starts up again. I can guarantee if the police report or if the criminal history indicates that there were other unreported acts of domestic violence, or there were other acts of domestic violence that that the court system is aware of because there's charges or no contact orders are standing, that is a heavy upward battle to ask a court to drop a order and allow those two people to interact again. If the alleged perpetrator in a case is going to get an evaluation or will probably get an evaluation, that would be an evaluation as to either their mental status, drug and alcohol evaluation, something involving their propensity for domestic violence. If you're going to file and ask to have a no contact order lifted in a case, wait to have that evaluation done and have your lawyer talk to the other lawyer and see what the results are of it. And if somebody's asking in the unique set of circumstances where somebody has entered a domestic violence perpetrator program or some kind of behavioral modification program focusing on domestic violence, there are certain keystone steps. For example, in domestic violence treatment programs, the classic advice was always wait about 3 months until the initial phase of the domestic violence treatment program is completed before you ask to have a no contact order lifted and interact with the person who is in a domestic violence treatment program. And there's a lot of very practical reasons why a judge will hold to that point of view and is not interested in backing off on it. You have to recognize that if family hardship is not a good reason to lift a no contact order, otherwise the judges would always lift the no contact order because someone would say it's creating a hardship. We can't live together. He can't see my kids. We have these issues going on. And so these are the big issue on these kinds of cases, especially with alleged victims or victims that are asking to have no contact orders lifted. And in my case, I've represented a number of people who have had isolated incidents. They don't have a pattern of abuse in their relationship. They have an isolated incident over their 15-year-old kid who's having behavioral problems. They have a dispute over children and discipline. They have a dispute over an affair. They have a dispute over something, and the police are called and there's an isolated incident. And in those sorts of circumstances, with the right setting and with the right prep work, I think it is reasonable for victims to go back into courtrooms and to expect to be able to get a lawyer to successfully argue that they can get a no contact order lifted. However, if there's a pattern of abuse, if there are old criminal charges, if police reports indicate that there are multiple unreported acts of domestic violence beforehand, and that a victim that wants, or an alleged victim that wants to have a no contact order lifted in those circumstances, is really looking at an uphill battle, because a judge at that point doesn't trust that the victim, even represented by counsel, is going to look out for their own best interest because they haven't done so before. And they don't have the wherewithal to recognize that objectively staying in a relationship which is steeped in violence and control and abuse is not acceptable from the legislature's point of view, and certainly the judge's point of view because of that. I hope this helps. It's a touchy topic, but it's an interesting one. Thank you.